So with that, I'm going to turn it over to my colleague, Jonathan Barnett.
Thank you, Sean. I'm a professor of law at the University of Southern California Gould School of Law. I have to say it has really been an honor and a privilege to work on this project. This is a unique project that brings together, if you counted it up, decades worth, probably centuries worth of brain power that has been invested in trying to better understand how licensing markets and standardization works in information technology markets. A lot of times when I tell people I'm working in this area, they say, isn't this kind of esoteric? To which I answer, well, do you consider your smartphone to be esoteric? Do you consider YouTube to be esoteric? The stakes here economically are immense. We're talking about the legal infrastructure behind the key communications infrastructure in our economic life, which has transformed so many industries. What we've tried to do in this project is to do something a little different from some other edited collections. And I'd like to bring to the attention of both our live and online audience that the book is available in hard copy form through many distinguished online and brick and mortar sellers, but it is also available in open access format through the Cambridge University Press website at no charge. And this project is unique in that it does not only consist of academics. I think it's roughly divided equally among academics, policymakers, and industry practitioners, and that's intentional. We wanted to break the boundaries between the learning that academics have the luxury of acquiring through analysis, but we wanted it to be informed by the realities of business markets that academics may not always be attuned to. And we wanted the insights of policymakers to translate those two sources of insights into policies and laws that actually impact markets. The last thing I'll say before we launch into the event is that this project tries to carve a route between a phrase that I've used before, between the dogma of ideology and the dogma of the model. These two dogmas have afflicted much of the scholarship and some of the policy approaches that have been adopted in this area, in the wireless area and antitrust generally. The dogma of ideology assumes reflexively that a patent right is always a monopoly. The patent owner has no competitive discipline, and of course that would invite antitrust intervention or intervention by courts almost reflexively. The evidence doesn't support that. The dogma of the model is a scholarly approach that relies on stylized mathematical models to derive policy conclusions. But the real world is often more complex than the simplicity that is required for mathematical models, which have their role, that they must be qualified by an understanding of how the market actually works. That's harder, but that gives us more nuanced policy insights. And that's what we hope we have delivered through the many distinguished contributions in this book. What we're going to do in our first segment is we're going to talk about some of the fundamentals of standards-based markets and the role of patents and standard essential patents, also known as SEPs, in the wireless markets. I'm going to invite Andrei Iancu and Scott Keefe to join me, and they will each deliver remarks on their respective chapters.
Well, thanks, Jonathan. Great to be with everybody. Great to see so many familiar faces in the room, and I'm sure more online, although I cannot see you guys. So let me just start at a very high level. And it's basically where my foreword was aimed in the book. The reality is that innovation in general in the United States is at the crossroads. We're coming off of the heels of the 20th century, where we were clearly the undisputed technological leaders in the world. Now, about a quarter of the way into the 21st century, that technological leadership is very much in question. The reality is also that our leadership is being challenged affirmatively and purposefully, at least by China and other players in the world. And the numbers are unmistakable on every measure that you can think of in virtually every area of the technologies of the future. We are losing ground or have already lost the leadership. When you count the number of patents, we are now way behind China. When you count the number of science and technological scholarly articles in peer-reviewed journals, we have fallen behind. When you talk about the number of STEM graduates with advanced degrees, we are way behind. You can quibble about each one of these and the importance of each one of these and the reality and how you count and so on. But the trends are unmistakable. They're all in the same direction. And importantly for our purposes here, the number of committee leaderships at standard setting organizations, China is making great strides there as well. So how do we, what do we do about that? And, and I say this with a little bit of bias, having been the director of the US Patent and Trademark Office, you cannot maintain or regain our technological leadership without a robust intellectual property system, without a robust patent system. You simply, in my view, cannot have a robust innovation economy without a strong intellectual property ecosystem. That inextricable link, unfortunately, in my view, is lost on our policymakers, both in the administration and on average on Capitol Hill, with just a few exceptions. And everyone wants more innovation. Everybody wants the United States to be an innovation leader, but not everybody agrees that in order to do that, you need a strong patent system. And this is more important in the standard setting area than any other area of technology. Because like with any other innovation, innovation is risky in the first place. You don't know if it's going to work technically, and you don't know if it's going to be accepted by the market, even if it works technically. That's true everywhere. And that alone is enough to require a strong patent system. But in the standards world, you also don't know that even if your technology works and is good, that if it's going to be adopted in the standard, you do all that work to develop it and invest the money, but you don't know if it will be adopted by the SSO into the standard. And then even if it is, you don't know the additional risk that the standard will be accepted on a worldwide basis. And then after that, if it is accepted, how you're going to get compensated for that and chasing implementers around the world. It is impossible in a free market economy to justify the heightened risk of that investment without having the reliance on the rule of law and knowing that if you finally succeed and the standard is, and the technology is adopted in the standard and the standard is adopted into products, that you can actually rely on the rule of law and recuperate your huge risky investment. But our patent system and our IP system is challenged on the, and legislators and administrators fail to see the necessary link here. And we can see that in the challenge with how difficult it is to enforce patents in the United States, how many potential challenges are available to infringers against the validity of the patents, multiple challenges that can be brought at the same time or in series by the same parties against the same patents. You have challenges with Section 101 that have to be fixed. There is no or very difficult way to obtain an injunction in the United States, especially for FRAND encumbered standard essential patents. And now we see the disconnect and the failure to understand how important a reliable patent system is in the minds of legislators with the push for a new royalty court that we see already gaining significant traction in Europe, adding yet another layer of bureaucracy and making it even more difficult on top of all the other hurdles for patent owners to enforce their patents after all the risk they have taken. And in the United States, there's also talk here of a similar royalty court to be established as well. Bottom line is, if the United States is to continue its technological leadership or regain ground lost, and if we want standards to be developed in the United States and American companies to be able to make the necessary investments to gain traction with and their technologies to be adopted into standards, for that to happen, our leaders absolutely must recognize that that cannot be done here without a robust patent system, and we need to fix our patent system and make it robust, reliable, dependable, and meaningfully enforceable. And I really look forward to the conversation today. I'm sure that we're going to hear great insights on all of that, as well as on the economics of the system.
Thank you very much, Andrei. Scott, let's turn to you. And after that, we'll open it up to my own questions and your questions.
Well, thank you very much to the organizers for bringing us together, to the Cravath team for hosting us, to Sean and Jonathan and the whole team that brought this book together. It's just a treat to work with each of you and the other authors on these topics. And I've learned so much from each of you as I've worked through your materials. It's really been a pleasure. I think this adds so much to the discussion, and I'm delighted to be included. The chapter that I enjoyed working on was a project that is a joint project with a colleague I've been working with now for almost 30 years, Tom Grant. And Tom and I and some other colleagues have recently put together a national trans university initiative at Cambridge and Yale and GW that looks at these technological systems that we're discussing through the arc of history. One of the technologies that we are most interested in is a technology that turns out to span human cultures. It's this technology called language. And in particular, the profession that uses language, our profession of the practice of law, among other professions like auditors, accountants, financial advisors. The idea is that those professions, these lawyers, these financial advisors, auditors, compliance monitors, one thing we are all doing is we're contributing around this technology called language to pick specific ways of linguistically framing a divided set of ideas. And that divided set of ideas might be divided across a collaborative network and might be divided across a competitive network. But we, as professionals, can and have been across time, across cultures, quite deliberate about some of the choices we make. And as kids, we learn it. I cut, you choose. It's a simple linguistic way of expressing a complicated set of risk and financial and transaction cost concerns. Will the two kids, the I cut, you choose, will they get each a fair piece of pie if one of them cuts and then the other one chooses? It harnesses incentives. In the patent debate and in the debates around patents, we can come up with different words. We could use a word innovation or invention. We could make the test for patentability turn on a word like that. And we have tried that in the US system. We've tried the so-called requirement for invention around what we in the US now call the obviousness test, what other patent systems in the world call the inventive step test. It's not that the word invention is a magically good or bad word, but it's that we as humans, especially as groups of professionals, groups who bring together both collaborators and competitors with sharp elbows and keen minds and powerful incentives behind them, we have played in the US system around giving practical meaning to the word invention. We did in the US system, for example, in the 100 years leading up to 1952. And we deliberately decided, through our political system, we voted a new statute. Our House, our Senate, our president all voted on that. We, the people, chose those people in a representative democracy to throw that away, to pick a totally different linguistic construct, the word obviousness, not because that word is magical, not because it's better, but because it gave us the opportunity to look backwards in time, to notice that we had two very different linguistic frameworks that had developed. One, a so-called objective test, the person having ordinary skill in the art, and one, this much more subjective test. To be an invention, and had to be an invention. That is tautological. We then started to develop these linguistic frameworks for harnessing that tautology. We said that someone had to have a flash of genius. If they knocked their head on the granite countertop and everyone saw stars, then it was patentable. If no one knocked their head, it wasn't patentable. And we decided we didn't want our inventors knocking their heads, and we didn't want the courts with the plaything of this tautological linguistic text. So the point of our chapter was to look at concepts like invention, concepts like the difference between a reward system, a prize system, and a patent system, concepts like the difference between what Andrei, I think, was getting at with, let's call it a more predictable enforcement system and a less predictable enforcement system. And we think that the technology of language, it can be expressed with different languages, it can be expressed by different groups, but we all are quite aware there are more objective, more predictable enforcement strategies, more objective linguistic structures, and there are more, let's just call them malleable ones. And the ones that are more malleable will always lead to either a nice political economy strategy where raising money in Washington is easy and spending money in Washington is easy, but developing the industrial economy is hard, or the opposite. Maybe it's okay to try the opposite.
Thank you, Scott. All right, I'm going to give each of our panelists a question. And after that, we'll open it up to the audience. So start thinking of some questions. Andrei, I'll start with you. I'm going to play devil's advocate here. Let's imagine that I were willing to accept pretty much everything that you've said. And to implement that, it sounds like a good place to start would be restoring the presumption of irreparable harm, so that patent owners would pretty much expect 99% of the time, if they defend the presumption of validity, they demonstrate infringement, they're going to get an injunction, just like pretty much any other legal right that we put under the rubric of property. But if we were to go down that route, wouldn't we go back to the world that existed prior to the eBay decision in 2006, described by at least Justice Kennedy and his co-signing justices, meaning we would restore the patent troll problem, or in the wireless context, the variant of that known as the holdup problem. So why is that really a good direction to go in?
Well, I'm glad that you prefaced that with being devil's advocate. Look, I mean, there's so many things that are wrong with that hypothesis. First of all, I don't think there is any evidence that that there was or is a holdup problem, and I think the literature shows that if anything, there is significantly more of a holdout problem by the potential licensees, folks who implement technologies, who refuse to take a license until their backs are at the wall, after lots of expensive litigation. So number one, I don't think there is empirical data to support that. Number two, even if it were, the concept that that not having an injunction solves that issue, I don't know where there's the evidence of that. And more importantly, that it solves, quote, a patent troll sort of problem without doing significantly more harm to the rest of the innovation economy. Here's the reality. Inventors and patent owners want their technology to be adopted. I've never understood this concept of holdout conceptually. Put aside the empirical issues. Why would anybody want to invent something and then not have it being used and receive financial compensation for it? What are you holding out for exactly? The whole issue is, am I getting fair compensation? And the market dynamics for patents or for real estate or any other type of property work out to, on balance, achieve the right results. Let me just say one more thing, and then I'll turn it back over. And that is that, look, no system is perfect, okay? Every system will have bad players, bad actors that don't behave in good faith, one way or another. And every system needs to recognize those, have mechanisms for identifying the bad behavior, and then have mechanisms for correcting the bad behavior. You don't effectively throw out the whole system in order to remove the bad actors. Sure, if you throw out the whole system, you will also remove the bad actors, but you're also going to remove all the benefits and the vast benefits the well-functioning parts of the system are doing. Any correction to what is a bad act or perceived bad acts should be focused and pinpointed and let the rest of the system flourish.
Thank you. Scott, your turn. Andrei just drew a connection in his response between property rights and fair compensation. And I'd like to point out to the audience that we have here in the room a number of scholars who have worked on what's sometimes known as the transactional function or the enabling function of patents. Professor O'Connor is one of those scholars. Professor Keith Scott was one of the earliest scholars, among others, to start focusing on that. And there's a word that you use, Scott, I think in this chapter, but I think goes back to your original article where you use a metaphor of the patent as a beacon. I wonder if you could draw out for us that beacon concept and this connection between patents and fair competency.
Yeah, thank you so much. I mean, I think one of the first things any capitalistic oriented or at least familiar audience can quickly find itself overly drawn to is a discussion of money. What's wrong with money? Money is great. Who doesn't like money? The problem is, if all of this were about money, we'd notice that a whole lot of things might be not working the way we say we'd like or are. So what do I mean by that? If every patent transaction were really about money and that's all, it would be a single sentence. There'd be a patent number, there'd be a dollar amount, and there'd be perhaps a have a nice day clause just to build some better relations. But these are 30, 60-page single-space documents. And that's because the parties are using these interactions to accomplish much more subtle, much more complex interactions. The government could give out prizes. That would be money. Who's against money? Once again, everybody loves money. It's money. The problem is, if all you do is hand out money as a policy, you run into a number of problems. The first problem you have is your own problem, which is how do you figure out how much and to whom? But the second problem you have is everyone else. In a system in which there is at the center some all-knowing, beneficent government, and all it does is hand out prizes, we all have a private incentive as individuals to stand in line and say, may I please have mine too? But we never have an incentive or an ability to stand next to someone else and say, I am so sorry. All of the things that have been discussed here today already, these seemingly arcane concepts, there might be some prior art to that claim. There might not be adequate disclosure to that claim. All of the incentives for someone on the other side to challenge patent validity, patent infringement, those incentives are gone in a prize system. But in a patent system, those incentives provide the ability for lots of us to come together and interact passively or actively around patents like the beacon. So to put it differently, if I were an amazing government official and I knew just exactly how many carrots every bunny rabbit would like to eat, then I could place on the table in front of everybody, whether they're inventive bunnies, whether they're manufacturing bunnies, we could call these bunnies whatever we want to call them. I could put just the right amount of carrots on the table in front of them and hope that they're going to hop to the carrot. But I need to have an immense amount of information about them, and I should have a lot of confidence that no one else is going to bother to make the other side of the argument. But in a patent system protected by an objective set of rules, enforced actually within a property right, is a system in which I, as the government official, and everyone else in the market doesn't have to figure out who's a bunny, what they ate for breakfast, how hungry they are for carrots, and whether there's a wolf or anything else in the room that's going to incentivize behavior. When a patent is enforced by a predictable property right, it can facilitate coordination among a vast number of market actors. It can serve like a beacon in the dark. It can draw to itself all of those who reveal to themselves and themselves only that they are interested in being drawn to that beacon, that light. They can elect to transact with each other or not, and they can design around and avoid. They can contract in or not, and they can do so on terms that they can then reveal through the published patent and perhaps the contract, at least to each other through the contract and to the public through the patent, only what they need to reveal. And they don't need to reveal any more to each other or the public or to the government actors. And that beacon-like effect of a property right drawing to itself provides incentives for everyone who shows up at the beacon to make the patent law arguments. Hey, I really don't think there's infringement. Hey, I really think there's prior art. Hey, I'm not sure the patent disclosure really supports that broad of a claim. When private actors have the capacity and the incentive to bring to each other that intense level of information and then only interact as they choose, we, the entire system, benefit greatly.
Thank you. I think we have time for about one question. Jeff
A
Braden.
comment. It
Yes.
seems to me that Director Iancu put his finger on what might solve a great deal of problems. The most federal judges have forgot that they have the ability under the rules of evidence to impose a bond for someone that comes in for a preliminary injunction. So you're not going to get trolls posting bonds in the district courts. And the standards have been slightly changed by the appellate court, the federal circuit, to make it a little more difficult to get an injunction. But the district court needs to remember that this is before discovery. You can't hold the party asking for an injunction to the same standard of proof as you would if they had had the opportunity to go through discovery. And Paul Michel has talked about the fact there were so few cases that ever came to the federal circuit on damages, because when people went during his time, because when people got injunctions, they basically worked out a rational business settlement. And it was nobody's business what they worked out. But the use of the injunction, to me, would basically preempt the burden that Congress has on obviousness and some of these other things which are so obtuse, that if we really focused our attention on preliminary injunctive relief, we could do a lot better. Now, you got at the last roundtable we had at the center, I suggested, and I don't think anybody's done anything about this, but when you become a new district court judge, you go to baby judge school. And most of the lawyers that are becoming district court judges do not have patent or intellectual property background, so they don't have a lot of training. The administrative office brings in professors primarily from anti-patent schools. And so we have basically seceded that area to the academics that are against what we're trying to do. And we need to be serious about this and get in before the AO and be sure that we say we want our stake in teaching the district court judges about patent law, number one, and number two, explain to them how they can get resources to help them. As Josh knows, and he was one of my interns, I took 6 interns every semester from different local schools. I specifically looked for people who had patent background for at least 3 or 4 of those slots. They can get free help. They can help the students. And I think you might have more district court judges that would understand the value of preliminary injunctions. They don't have to worry about the federal circuit that way.
All right, Scott, sounds like you're ready to go.
I was just going to
Response to
offer one other brief thought. It is often said in these debates about patents, this large, great entity itself does inventive work, itself has a patent portfolio. How could it be anti-patent? Whatever that it is. And one of the things I just think we should notice is that a patent system in which people are using patents like those beacons will look one way. It won't be that way. A large entity that has a large patent portfolio, we might ask, well, gee, what are they doing with that portfolio? Well, let me just be really clear. There are a number of things they can do with that portfolio that may or may not even have much directly to do with inventing and rewarding. It can look very different. One, it can be a way for large players to collude with each other through transactions or litigations, complaining about the transaction cost of litigation while communicating quite effectively. Discovery is expensive. Discovery takes time. Discovery is a trusted, long, high bandwidth comms channel around which there can be collusion. And when antitrust regulators regulate in that space, it is happening in front of district judges. And therefore, it is, at least to a large degree, antitrust immune, at least from, let's call it, criminal enforcement and treble damages. It may not be immune from structural remedies, but those may either be not a high price to pay for those parties or desired by those parties. The second strategy is to interact with their own food, safety, environmental, or antitrust or other regulators and say, look, allow me to continue to operate even if I have an environmental footprint, even if I have a labor footprint, even if I am in some way regulatable, but let me charge a higher price, at least as a function of how innovative I am. And how will we measure how innovative I am? We will count patents. But notice that in that setting, the regulator of choice is not at least interested in any way in patent validity or patent infringement. They're a regulator of some other discipline. And so they're merely using the patent as a proxy for what both parties in that transaction, the government regulator and the large entity being regulated, can pretend is a measure of innovation. The last strategy is a strategy in which the so-called patent tax box, a way of locating either a capital asset or a cost or an income stream in a jurisdiction with a low tax rate or a high tax gain offset rate, is a strategy in which you park your large patent portfolio in the place in the patent box where the tax effect gives you overall a low tax consequence. Yet again, another setting where none of the discussions of patent validity or patent infringement, none of the specific things that would happen around a beacon are occurring. It's all an ersatz or fake way of just pretending we're all innovative. We all have lots of chits we're trading, but it's to play a totally different game.
Thank you. I'd like to thank Andrei and Scott for getting us off to a great start. And I'm going to invite Maureen Olhausen to join me at the head of the table here. Andrei gave us some thoughts about why these issues are so critical and important. And one of the things that he mentioned was the geopolitical, the national competitiveness factors. And I think that's one of the things that Maureen is going to touch now on in her chapter. And since the publication of the book, it's the geopolitical issues have gained greater prominence in IP policy issues. With that, I'll leave it to you.
Great, thanks so much. Yeah, so in the chapter, I and my co-author, Yana Seidel, who some of you may know and work with, trace the evolution of IP and antitrust, the interface really starting in the 70s. A lot of these things came really to a head during the Obama administration. There was a big focus on those issues. There were developments in Supreme Court case law that kind of moved us away from the 70s, but in the Obama administration, big focus on, injunctions and is that an antitrust violation, and the Qualcomm case, and there was a 2013 statement on remedies that some people had kind of interpreted as saying you can't get the same remedies for SEPs, right? That there was some disfavoring. So, and there were revised IP guidelines that came out in late 2017. So the chapter goes through that, but as an initial matter, I'd like to focus a little bit more on what's happening now, right? So in the, I think there was an expectation that with the return of a Democratic administration, that they would kind of refight, right? Kind of restart a lot of these battles. And I think initially there was an indication that would be happening in the president's executive order on promoting competition, which was in July 2021, which encouraged the Attorney General and the Secretary of Commerce to consider reevaluating their positions on the intersection of IP and antitrust, ostensibly to safeguard the standard setting process and to stop potential harm to competition from industry participants leveraging their IP in any competitive ways. So one of the first things that the order suggested and the antitrust agencies tried to do was take a look at the division's 2019 remedies statement. So there was this 2013 remedies statement that had been interpreted as sort of disfavoring remedies in the SCP space. There was a 2019 action under in the Obama administration that rescinded that kind of made this clearer that you can get the same remedies for violations of an SCP right as you can for others, that there wasn't a different standard. I think we're all familiar with that. So there was a new draft remedy statement put out, and it also had followed a speech by the Department of Justice's Economics Director of Enforcement, Jeff Wilder, and it previewed some significant shifts and suggested that, well, yes, there may not be a unique set of legal rules for SEPs subject to FRAND commitments, but there were these sort of things that were, I think, more broad and suggesting, well, maybe there should be, and maybe negotiators should or shouldn't do different things. That got a fairly, I think, strong reaction in comments. Jim Rill and I filed a comment together actually on it. And the division and the USPTO, so the Antitrust Division, USPTO, and NIST said, okay, they were withdrawing the 2019 remedies statement, but not putting a new one in, and they were just going to do case-by-case enforcement. And so things have been pretty quiet on that front. And one might think, oh, well, perhaps it means this really isn't a focus anymore. But what I would suggest is that, we're seeing changes in Europe, obviously, with others have already talked about, I think, some of the proposed legislation. And certainly Europe has a different antitrust regime, right? It has an abuse of dominance standard. In certain cases, it even has unfair pricing. We don't have anything like that in the US under the antitrust laws. But what we're seeing instead in the US is this movement towards adopting broader antitrust liability standards across the board. So in the Obama administration, there was more of a focus on trying to make these changes in the IP antitrust interface. But now what we're seeing is trying to have those broader theories of liability and government oversight of these kinds of interactions more broadly. So not just limited to IP. So I think, you don't want to kind of miss the fact that because it's not being pursued in a narrow focus channel, that it's not being pursued. And one of the ways I really see this happening is really through the FTC. So, obviously in the Obama administration, the FTC was a big actor in this space, but under traditional antitrust case law. So even in the FTC's case versus Qualcomm, they were arguing it as a traditional Sherman Act violation, which has a whole body of case law that is very, imposes very high standards for liability. Obviously, they didn't win it in the Ninth Circuit. The court was very clear about that. But the FTC has not given up. What it's done now is adopted a broad, so the FTC has unfair methods of competition authority, and that is how it asserts its antitrust authority, right? So anything that's a Sherman Act violation is sort of by incorporation an unfair method of competition. And there's been this question of, well, okay, we have the Sherman Act, and the FTC has authority in the Clayton Act too. We have the Sherman Act and Clayton Act, DOJ, FTC can both enforce those. But is there a broader concept of unfair method of competition that goes beyond the boundaries of these defined statutes? And ergo, the defined case law that has put some pretty strict limitations on these things. So in November 2022, the FTC adopted an unfair methods of competition policy statement that claims a very, very broad authority beyond the the boundaries of the Sherman Act beyond the restrictions that courts have put on these authorities. And it says, okay, well, what's an unfair method of competition? Well, it's a method of competition. It's not just sort of an underlying market condition. But that obviously is an extremely broad bucket of things. But it also is something that's coercive, exploitative, abusive, predatory, or involves the use of economic power similar to those issues. So that's very, very broad. And the FTC also says, well, if you can show this, it can, in some circumstances, almost be a per se violation. You don't have to have kind of the same levels of proof. You can say it's just bad for economic competitive conditions overall. So in this, one of the things they identified as like, someone might say, give us some examples. So they give a few examples, very broad examples. But one of the stated examples is inequitable practices that undermine the standard setting process. So if the FTC is considering that using your power in a way that they could consider exploitative or abusive, and that could undermine the standard setting process, that to me, to my mind, seems like a clear way to circumvent the case law that they don't like, to circumvent the fact that, some of their proposals, they haven't been able to get through Congress, and to adopt kind of a new approach. So what is that? And on antitrust more broadly, the current antitrust leadership has been trying to embrace a much more expansive view, much more like the European view. We still don't have abusive dominance in the US, but there's a lot of theories that they're trying to push to be close, and unfair methods of competition is definitely one of them. So how would they do this? So there's case-by-case enforcement, obviously, but the FTC is, I think, in a very strategic way, trying to adopt an unfair method of competition rule, using this rulemaking authority that it has never exercised in its over 100-year authority on its own, just saying unfair methods of competition rulemaking authority, not combined with its consumer protection rulemaking authority, unfair and deceptive acts or practices, which is well supported by specific congressional legislation called Magnuson-Moss Act. So they very strategically picked non-competes. So you may be aware of this, the non-compete rulemaking, and think, what does that have to do with IP? Well, here's what it has to do with IP. It's a very sympathetic topic. It's something where it says like, well, a lot of people think, well, maybe that isn't really fair to workers. Maybe it is anti-competitive in some ways. And I'm not here to say non-competes can never be anti-competitive. I think they can be, but they've been considered on a case-by-case basis. So the FTC is pushing forward with this unfair methods of competition rulemaking. It's got a lot of political support. But the real question, the real game there is, do they have this authority to do competition rulemaking? And I don't think they do. I don't think the statute supports it. And I don't think the current Supreme Court, in its kind of more stringent statutory interpretation, looking for actual sources of powers, not, the one case, there's a DC Circuit case that supported this kind of hybrid FTC unfair and deceptive acts and practices and unfair methods of competition rulemaking that essentially said the statute doesn't say you can't, ergo you can. So that was sort of, and what I would say an out-of-date statutory interpretation. So if they get this unfair methods of competition rulemaking authority in place, right, if they get it upheld, and by the way, they also claim it preempts all the states. So they're preempting like 30 different state laws. This is the template through which they will then implement exactly what they wanted to get in those other cases, like the Qualcomm case where they were not successful. And they will say, using your, SEP to try to get an injunction, using your SEP to try to get a supra-FRAND rate is an inequitable practice that undermines the standard setting process. It's an unfair method of competition. There's a rule against it. We have the presumption. You need to, you can't really rebut it. And you have to, the FTC can get an injunction and get high fines. So that's, I think, sort of keeping your eye on the ball of sort of, or, where that puck is going.
Yeah.
use that. So,
As Wayne Gretzky says.
yes, so I think that as we see these changes in Europe, that maybe are more, even if you don't like the changes, I think they're more express about what they're doing. This is how I think the current leadership would do it in the US without actually getting nothing, you know, Parliament is doing one thing in Europe. Here, I don't think Congress is gonna make those changes. Here's how I think that will try to be pursued.
Thank you. I'm going to make an observation and then a question for you, and then we'll take one question from the audience. So you got to be quick on the Jeopardy button here because I think we only have time for one question. Observation is that without reformulating your whole chapter, but the bottom line of the chapter that you co-wrote with your colleague was that there was a certain degree of convergence between the EU's approach to the hold-up/holdout problem through the unwilling licensee concept, and that what we saw in the US courts is perhaps not as explicitly structured, but it wasn't too far apart, and there seemed to be perhaps a happy balance. That apple cart got upset by the developments that you mentioned, that the DOJ and some other agencies took on the heels of the Biden executive order. That issue is now set aside. That's been withdrawn. And you make the very interesting observation here about, well, there's this other activity happening through the UMC channel. And here's my question for you. This is gonna be a very lawyerly question, right? So we typically draw a distinction, especially in antitrust law, between what at least scholars sometimes call soft law, hard law, right? So agency can really say anything it wants, right? But that's not going to be binding law until it's been tested before a federal district court. Nonetheless, the soft law can have a lot of bite to it because it can cause enough friction in the market that it changes behavior. And in fact, some observers might say that the agencies, and especially the current FTC, has pursued that very strategy in the merger review area, where idiosyncratic theories of merger liability almost always, I think I could say always, but I'll be lawyerly and say almost always have failed when they have actually been tested before a federal judge. But nonetheless, they do seem to be inducing parties in the market to either pull transactions or never undertake transactions because it just causes enough delay, enough cost. So taking that distinction, you've identified a risk out there. Can we calibrate that risk? How strong is this? How seriously should we take this UMC regulatory activity?
Well, you're certainly correct that the FTC and the DOJ, but the FTC, I think more aggressively, has tried to use sort of the bully pulpit and things like the merger guidelines, right, to articulate sort of a different vision rather than saying, you know, here's what the courts say or the standards of legality, but here's what we wish the court said. Maybe we can convince them if we put it in the guidelines that they'll do that. Changes to the Hart-Scott-Rodino Act filing document to be much more onerous, to collect huge amounts more information, to try to deter mergers and try to feed into some of these different theories that, you know, they haven't been successful on in the courts. So they've definitely done that. And they have really used, on the non-competes, right, really used this as a way to, even if the rule founders on the basic authority, which is what I think is going to happen, they've changed like a lot of behavior and a lot of like recommendations. So I think that, you know, as a person counseling companies all the time, there's the question of, would you win in court? Would you win at the Supreme Court if you had to litigate this all the way through, right? And that's one question. But there's another question, which is, do you have the, time, interest, be willing for the opportunity cost to do that? Right. So I think the soft law and the bully pulpit approach really has that effect because, there's a lot of companies are saying, well, I have behavior or I have a transaction that I want to do. Do I want to get investigated? Do I want to have to fight it all the way through? Or is there an option that I can take where that reduces that? So that's, I think, where it's having the effect. Like I've seen, not for IP reasons, but I've seen deals not go forward simply because of like, well, there's nothing anti-competitive about it, but it's also not worth, the time and the mind share of the executives to get caught up in, ultimately fighting it out and winning. I don't know if that answers your question. But that's sort of the pragmatic
answers it
side of
very
things.
well.
So.
Great,
right.
so let's have an online question this time.
All right, all right.
So your chapter suggests a growing acceptance by US policymakers of legal developments in the EU that have promoted a more balanced approach in SEP licensing negotiations in Europe. With this background, can you, the author, comment on the recent EU SEP legislation?
Well, I mean, what my chapter talked about, I think, was the fact that, and I think you mentioned this, that in Europe, I think they were more clear about what was sort of good faith, what were the good faith steps to undertake FRAND negotiating, right? You have to say you have these IP rights. You have to, try to assert them. And then on the implementer side, you have to, come to the table. You have to have an offer within a certain amount of time, things like that. So that's where I saw the convergence going. Now the new proposal, to my mind, obviously there was a lot of pushback on it, but it seems to be going forward. I think takes a much more of centralized government regulatory approach rather than sort of policing around the edges to make sure that this private ordering is kind of following the rules and not being exploited by either side. So is the US going towards more of a government control of business kinds of day-to-day business decisions? If you read the unfair methods of competition policy statement, that's definitely where the FTC.
Thank you. We're ready.
Yeah.
All right, Maureen, thank you very
You're welcome.
much. And I'm going to ask David Kappos and Greg Sidak to join me here at the head of the table.
Great job.
Let's try to see what's coming.
Greg, why don't you go first and David will follow.
Thank you. My chapter is entitled "The Fair Division of Surplus from a FRAND License Negotiated in Good Faith." Now, I think I'll mostly address the topic of good faith, and we can get into the fair division of surplus later on if that's of interest. My starting point is that the FRAND obligation is something that is rooted in contract law. There's an obligation undertaken by the SEP holder to the standard setting organization that creates a right in an implementer as a third-party beneficiary to request a license and be granted a license on terms that are fair, reasonable, and non-discriminatory, FRAND. FRAND, in my view, is distinguishable from RAND because fair is not an insignificant word to add to the description, and we can talk about that a bit as well. In recent years, I've been doing testimony as an expert witness on FRAND cases in Europe, particularly in Germany and the Netherlands. And one of the things that I came to realize is that although FRAND is a contract, the way lawyers and judges seem to be approaching the interpretation of that contract was quite different on the two sides of the Atlantic. It was even different between the United States and the UK. And so that's what the chapter is about. There are a couple of key concepts that I think underscore the difference between what I'll call the European approach and the American approach to FRAND contract interpretation. And they involve what economists describe as an activity rule and a closing rule. Now, in American law, you think about first-year contract law and you're learning about contract formation. There's an offer and an acceptance. Now, what if there's not an acceptance? What if an offer is made and the offeree rejects the offer or makes a counteroffer or doesn't respond at all? After some commercially reasonable amount of time, it's deemed that that's tantamount to a rejection of the offer. That's the end of the story. There is no contract formation. There's no obligation on the part of the offeror to go back and say, well, you didn't take my first offer. I'll make a revised offer. That's definitely not the way courts look at the FRAND obligation, that the SEP holder can just walk away. Now, suppose that were the way it was interpreted, let's say by American courts. What would be the consequence of an offeree rejecting or counteroffering or not responding? It would be deemed not to be contract formation, and the SEP holder would then be able to resort to all of his rights and remedies under the Patent Act. So this is an important question. It's not strictly a theoretical question. And how does the European approach differ? There's this act of offering, making a FRAND offer. The offeree then typically will not accept, but rather counteroffer. And then there are rounds back and forth like a ping pong game. When does it end? That's part of the, people talk about holdout. I just prefer to describe the phenomenon as a lack of contract formation. And what seems to be missing, or what has been missing, at least up to this point, is a stopping rule. If you think about baseball, there are 9 innings, and then the game is over. Cricket, on the other hand, seems to go on for days. So there's a different stopping rule. What explains, why one game with a bat and a ball seems to, take twice as long as another? And the American approach has a natural stopping rule in the sense that if a good faith offer is made and it's not accepted, the game is over unless the offeror wants to make a new offer and keep the new negotiation going. But in the European approach, as I said before, it's more like merely the beginning of this iteration back and forth. So there needs to be a stopping rule for that not to become abusive on the part of the implementer, the offeree. Another concept is the activity rule. You think about a game of poker. If you want to stay in the game, you've got to keep putting money into the pot. This is basically the insight that economists at the FCC had 30 years ago when they were designing spectrum auctions. You needed to, the way spectrum was auctioned, it was an ascending, simultaneous, multi-round auction. So the price was bid up, and people were simultaneously bidding in different parts of the country for different aggregations of spectrum. This is what Paul Milgrom got the Nobel Prize for, the ascending multi-round auction. But they needed to have a rule to know, well, to keep parties invest in the outcome of the auction. So you had to keep chipping in if you wanted to stick around for the next round. And the rounds would go on sometimes for many, many days. There isn't anything currently like that in the European approach. So one of the recommendations of my chapter is one of the most useful things that regulators could do or policymakers could do would be to think about optimal stopping rules and activity rules in a FRAND negotiation so that it doesn't descend into this protracted process. And it's not just inconvenient for the SEP holder in that situation. I mean, what we care about here is getting the technology licensed and implemented and delivered to consumers in products that they value. So there's definitely a public interest in getting on with it. I call this concept expedition. And it's I think that is one of the really significant cultural differences maybe between American law and lawyers and lawyers in Europe. I think Americans are a lot more impatient when it comes to negotiation. Given these kinds of thoughts in the chapter, I was really interested to see earlier this year an order that Chief Judge Gilstrap issued. For those of you who don't know, he's probably the busiest patent district court judge in the country. And the case is called G+ versus Samsung. This particular order came out on January 22nd of this year. And he had to interpret this. This was a SEP case governed by ETSI, so it was controlled by French law. And Judge Gilstrap had to issue an interpretation of French law. And he says in part this: if in negotiating for a license to a patent burdened by a FRAND obligation, either the patent holder or the implementer of the adopted standard fails to act in good faith and thereby prevents a license from being granted, the other party's obligation to continue negotiations is suspended. This does not remove the burden of the FRAND obligation from the patent, but avoids obliging a party acting in good faith to continue negotiating with a party who fails to do so. If the bad actor ceases its bad faith and begins acting in good faith, the good faith negotiations must also resume. So I applaud that. I think that's the right, that's a step in the right direction in terms of breaking the logjam of the FRAND contract negotiation. So I'll stop at that point.
All right, thank you very much. David, we'll turn to you and then we'll open it up to questions for the remainder of our time.
Okay, thanks, Jonathan. Great comments, great.
Thank you.
Well, great to see everyone and to spend some time talking about this book, and congratulations, Jonathan.
Thank you.
Really great
Thank
book,
you.
and I know it's been a couple of years in the making, right? So super to see it come out. I should preface my remarks by saying that Jonathan could make them better than I can. He's the co-author of the chapter that we put together, and thank you for your leadership on all of that,
Pleasure.
Jonathan. So look, what I tried to explore with Jonathan was this concept of, in this world that we're living in post-eBay, where in practice an injunction is basically not available in the US, what are the implications of that? And so we study through 4 case examples the implications, and there is probably people in this room and online already understand when you're a well-resourced party operating in a standards development organization-based ecosystem, and you're not compelled by the threat of an injunction to take a license, you are highly incented to not take a license. You are highly incented. In fact, as the then chief lawyer at Apple aptly put it, it would be malpractice to take a license, because your other alternative is the far better one. Your other alternative is to give the Heisman hand to the patent owner, dare the patent owner to sue you, and once sued, consider the litigation to be an option against showing the patent is invalid, in which case you have paid the option fee and you have no further obligation. Where the worst case of the option not working out is that you simply have to pay the cost of the license that you would have paid ex ante had you taken the license. But of course, you get to the time value of money working in your favor, and the fact that we all know as people who negotiate these licenses that interest is almost never actually made available when a license concludes. So you're way better off as a well-resourced licensee to wait, get sued, litigate in court, try to prove the patents are invalid. And if you fail at all of that, just take a license for the same amount you would have been able to take a license in the first place. So the situation is badly flawed. The incentives are badly distorted at this point in the post-eBay world that we're living in. And it should be no surprise then why we've had some cases, not as many as are alleged, but we have had some high-profile cases of well-resourced implementers simply infringing and going down that road. So with that in mind, right, what Jonathan and I explored was, so what are the alternatives then, or what is the fix? Well, the best fix, right, the number one alternative is to reverse eBay, right? And many of us would love to see that happen. But of course, that's a legislative fix, and it's going to take some time to get done. So we then discussed, well, is there a next best alternative in a world in which you've got to live with eBay at least for a while longer? And what we suggest is, yes, there is. And in fact, it was since implemented in Germany, which is to tap into 19th century US law that used to increment damages findings, even absent a showing of willfulness. We now think of, incremented damages findings or treble damages in the US as something you get if you show that infringement is willful. Well, it turns out that wasn't always the case. And there was a notion, and there now again is a notion in Germany on the back of some legislative changes they made, actually after we wrote this article, that find that in a case where an injunction is not made available, whether the infringement is determined to be willful or not, the court has discretion to increase the damages award as a way to shift responsibility and incentives, right, back in the direction toward taking a license rather than in the direction toward litigating. So, we then finished this paper by trying to balance the fact that if you jack up incentives too much, right, you're going to get back into some other discontinuities that we faced in the early 2000s. So the view is, you give courts a fair amount of discretion. Judges are usually pretty good at working with that. And you've got a system then in which, until we fix eBay, at least damages can be incremented a bit, and well-resourced infringers then won't be mandated basically to just infringe.
Thank you.
Did I do justice to it, Jonathan?
More, whatever is more than justice, you did it. All right, we'll do the same format here. I'm gonna have an observation. I think it might be a question for both of you, and then we'll take questions. So if you've been didn't get to ask your question previously, we're gonna have some time. So my observation is the following: those who participated in the scholarly work on SCP policy have witnessed, I think, what some would view, I would view as a evolution of the literature towards a more balanced position, right? So if you go back, and this has been reflected almost hand in hand in tandem in terms of policies. One of the interesting things about this policy space is a close conversation between scholarship and policy. And where we started was with this very stylized patent holdup model with the licensor who only licenses once and they're never going to be in the market ever again. Okay? And some scholars started questioning this. Why? Because there's a paradox here, because the model predicts massive market failure. But when we look at the actual markets in which these patents are being licensed, there's never been a market, perhaps until ChatGPT, that's been adopted faster. And we get a classic efficiency result of market output expanding and adjusted for quality prices declining. So if we want to do rigorous scholarly work, we might want to go back to the model, or we might want to collect some facts and see maybe the world is a little bit more complicated than the model. And that's exactly what turned out to be the case. The world was more complicated for a variety of reasons that I won't go into. But one of the key findings, and I'd like to mention that one of the chapter contributors was Alex Galetovich, who along with Steve Haber, Lou Zaretsky, who's in the room, Ross Levine at Stanford and Hoover, and Alex was at various universities in Chile. They did the painstaking work here, not relying on the narrative, not relying on the slogan, actually going out to collect the data. Greg has also done similar work. Keith Mallinson did similar work. All of these studies reached the same conclusion. The royalty rate was low at a constant rate throughout the inception of the industry. That fits the market. That explains why the market grows. Now, in Maureen's chapter and Jana's chapter, right? They talk about the convergence between US and European law. Why did that happen? Because policymakers, at least some policymakers, were receptive to what was coming out of the scholarship. The patent holdup may be no more than a theoretical risk. And therefore, if we've been adopting policies to address the problem that perhaps does not exist, we induce other dysfunctionalities. And that comes back to my question to you, which is, we know a lot more about how these markets work. We have data that gives, with a pretty high level of confidence, we understand how these markets work. And it tells us that policies that are focused only on holdup are not going to be the right policies. Greg, David, you both come up with certain solutions to try and balance out the interests of innovators, implementers. I'm going to give you kind of a big picture question. We generally think that markets will work efficiently to move away from practices that are not efficient. Why haven't markets done that? Why haven't they adopted arbitration rules, for example, Greg, that could have adopted your rule? Why don't we see more private ordering to try and address this issue, get the litigation down, get the licensing moving faster?
Well, I'll give you maybe an answer by analogy. In 1996, Congress enacted the Telecommunications Act, and it obligated local exchange carriers to open up their networks for basically to be leased by competitive local exchange carriers. And the statute envisioned that these would be commercially negotiated rates paid by the CLECs to the ILECs. And if the commercial negotiations deadlocked, the CLEC could go to the State Public Utility Commission and have a binding arbitration imposed on the incumbent. So there were perhaps 500 such bilateral negotiations that took place. Not a single one of them avoided arbitration, binding arbitration, because it was more advantageous for the CLEC to reject, the first offer from the ILEC and take it to a regulator who would be perceived as not succeeding in his or her job if the entrance to the market were kept out. Right? So the process itself created, the same kind of attractive option problem for the access seeker that David was just describing.
Your thoughts?
Yeah, so Jonathan, I would challenge the premise of the question a bit in two ways. Number one, despite the rhetoric about patent wars in the SEP area, when I looked into the empirical data, and this is a different paper, it turns out there haven't been that many lawsuits. There have been most years since, I think, 2005, there's been one or two or three. There's been a few years in which there were double digits. And it turns out that there's been one company on either the D side or the R side or both that's been responsible for over 40% of those. And that one company is Apple. So if you take Apple out of the equation, you're talking, nickels and dimes in terms of the number of SEP lawsuits in just the US, where there are, as you know, thousands of patent infringement lawsuits filed. So I don't think that the reality is as bad as the rhetoric on the numbers of these suits, and the data does not show that there's been any kind of a war, SEP war. The second part of the question that I'll challenge a bit is that there hasn't been progress made in terms of private ordering regimes. One word answer, Avance. There has been progress made, and it's been brilliantly successful, and it balances the needs of the licensors and the licensees. So, hopefully everybody knows, but if you don't, if you are a smartphone maker or an automobile maker, you can get the Avance license, which covers now something like 98% of all of the patent stack that's required to implement 5G, 2G, 3G, 4G, LTE, and 5G all stacked up together. And I think they just raised their price to something like $32 or somewhere around there. And so think about how this is actually working. If you are Daimler, you can sell a 150,000 euro automobile paying a one-time charge of $32 to get essentially the entire 5G stack. And then you get to charge your Mercedes customer every month around 30 euro a month for every month they own that car to keep access to that. The automaker, and I don't mean to pick on the German automakers, the American automakers, the Japanese automakers, they're all making a killing, paying almost nothing. It's 32 or whatever dollars. You spend more than that to wash your car once, right? And that gets you the whole stack forever. You're paid up, and you could go and just print money. And that's what all the automakers are doing now. So I would answer the question by saying private ordering regimes have come about. Could there be more? Yes, and that would be great. But they're wildly successful. And what they really reveal is a certain schizophrenia on the part of the auto industry, where on the one hand, you have the practical executives that are building the businesses, getting these great licenses and going off and then building automobiles and coming up with really very clever monetization models then that get, if you own one of these automobiles, you find out very quickly, you're now paying a subscription. It's not like the old days when you bought a car and you drove it off the lot and you're done with them. And so the automakers at the practical level, the business executives have been very clever at building a new business model on the back of 5G, while the lobbyists, frankly, in Brussels in particular, are still running around essentially like chickens with their heads cut off, screaming about how unfair the SEP licensing regime is. And so I think that's really where there's certain schizophrenia that's set into the auto industry between the policymakers on the one hand and the policy advocates on the one hand and the business on the other.
Thank you.
Sorry,
Just-
overtime. We should do one question.
Over time, I want to ask Lou if you have a question, because you're one of our chapter contributors and
Oh, sure. Well, I mean, there's an interesting remark a moment ago about the notion, I forget the exact terms that were used, but somebody pointed out that this just sort of works as it is, more or less, in the SEP licensing space. You know, do you feel like there is a true market for SEP licensing today? And I mean, Greg, you've studied this a lot, right? So, I mean, how would you characterize the nature of the cellular SEP licensing market today?
I'm sorry, I didn't hear what you.
How would you characterize the size and nature of the cellular SEP licensing market today? And to what degree do you feel like this constitutes a real functioning market or does not?
Well, I guess I would characterize it, the market as enormous. I mean, as David was saying earlier, we don't really have examples of an inability to license the technology. We have price adjusted quality, skyrocketing in deployment of technologies across markets, product markets and geographic markets being, very successful. So I think we've advanced a long way in terms of working out some of the sticking points in negotiations and recognizing that certain arguments that are made in negotiations are they're advocacy and posturing. And that goes on all the time in commercial negotiations. And in this situation, because there's the backstop of government, antitrust enforcers and others, those kinds of arguments are, I guess, are presented in a more contentious and litigious way, but that doesn't mean that they're necessarily correct.
So I think that we're over time, but if people want to stay a few, we could go till 2:00 perhaps if there's more questions. There are some online questions too. Do people in the room have some other questions? Is it okay if we stay a few minutes? Okay. Yes.
Yeah, hey, there's been a lot of talk about how the way the patent litigation works in the US basically made things very difficult for people who own patents. And I imagine this would drastically affect especially smaller companies that find it even harder to cope with the cost of litigation. To what degree is this maybe driving a push for smaller innovative firms to have to merge with larger entities to be able to, fight the litigation they're likely to end up dealing with their business?
I don't have a particular opinion on that.
This is Jonathan's
I can.
Scott, keep
All
that.
right.
Well, I do think history gives us an admitted imperfect, but perhaps useful natural experiment to try to explore that question. Before 1980, the US, Europe, and Japan, in various reasons, in various ways, you can like it or not like it, but it is broad consensus that it is so, prevented in practical ways patents around basic biotech. After 1980, we in the US, again, in very concrete ways, shifted our system to allow that. We can debate whether that was good or bad. But one thing we can observe, technology flowed across national borders, capital flowed across national borders. There were large biotech firms, Kirin, Amgen, Merck, whatever. There are today. But only in the US and only after 1980, with that big shift in these basic rules, did you see hyper proliferation of diversity in firm size, small and medium-sized biotech companies, and drastic increase, not in scientific publications, but in the number of new drugs and devices actually flowing to market? So if the claim is patents in this space caused concentration of firm size among big firms, the data points in the opposite direction. Maybe data doesn't matter. I don't know. I think science matters. If the argument is access to medicine is a social good, then being able to read journal articles published about medicine may help people feel emotionally better or intellectually better, but it doesn't cure disease. The drastic increase in new drugs and new devices coming to market cures disease. Again, maybe science matters.
Great, thank you, Scott.
Great. One more online question, and I think we should close it out. One
Okay,
more online.
all right.
All right, so Greg, this goes to you. In your chapter, you base the fairness principle of Fran standards on contestable behavioral assumptions. With cognitive biases, for example, efficiency may not always be enhanced in such contractually binding SEP negotiations. Any comments?
I'm not sure what the question is getting at. The basic idea that I'm presenting in the chapter about an economic meaning to impart to fairness is that a reasonable and non-discriminatory rate is reasonable because there are positive gains from trade. There is surplus that is created. Then the question becomes, how does the SEP holder divide that amount of surplus with the implement? Fairness could be then an overlay on top of that. Do they split it 50-50? Is it like an ultimatum game in game theory? In my experience in patent litigation generally, not just SEPs, the SEP holder is getting a small percentage of the gains from trade and passing the vast majority of the surplus onto the implementer, who keeps some of it, but also passes some of it on to the consumer. So I'm not sure I understand what behavioral
And
problems are.
just as a closing remark, I'll consolidate both the comment Greg just made, the data point that David gave us on the almost nominal percentage that the Avanci license constitutes out of the motor vehicle. And I'm going to bring that together with our first speaker, Andrei. What is that telling you? Patent systems got to be one of the best deals ever invented, because there is so much social value being created and such a small percentage is retained by the inventor, who nonetheless invents it's a system that's worth keeping and preserving. I'd like to thank everyone today for taking the time, your valuable time to be here. It was really an honor to share our book launch with you. Thank you.